Good morning. I would like to thank the Oklahoma Historical Society for inviting me to participate in this conference. Today I'm going to be talking about considerations of history related to the recent Creek Nation reservation cases, the McGirt case and the Murphy case. I had the opportunity to participate in those cases by co-authoring an amicus brief in each case on behalf of the Cherokee Nation and several historians and legal scholars. And our objective in writing the brief was to present to the court background so that it would have knowledge of the histories of the tribe when considering the interpretation of the treaties and statutes that control the decision. And while the court found that the statutes and the treaties text did control the outcome of the case, the court also displayed in its opinion its understanding of the history and also its understanding of the tribal perspective related to that history. In contrast, the state tried to steer the court away from considering the text of the statutes and treaties, and instead argued that contemporaneous understandings and events surrounding enactments of those laws, as well as post-statehood treatment, proved that the Creek Reservation had been disestablished. And the state provided a variety of historical snippets to try to support its argument that Congress intended to establish a homogeneous position by authorizing the state of Oklahoma to be formed. And the state also attempted to preserve the myth that the 5 tribes had been terminated, a myth that has been perpetuated for more than a century. I'm going to gear my discussion today to non-attorneys, but of necessity, I'm also going to have to talk some about legal concepts related to the case. And I'm going to start by discussing briefly the definition of Indian country and its significance. Then I'm going to talk about the state's position and the court's determinations related to that position. I'm also going to talk or provide a historical overview of the 5 tribes, which I feel is an area that unfortunately Oklahoma education, at least in the lower grades, has not sufficiently covered for many Oklahomans. And for that reason, I think a lot of Oklahomans are not familiar with that history. And then finally, I'm going to just briefly provide a statement about the 5 tribes post-statehood. So I'm going to start by switching over to PowerPoint, so please just bear with me for a moment while I do that. So my presentation today is entitled Significant Historical Perspectives in the 2020 Creek Nation Reservation Cases, Murphy and McGirt. This is a photo of the old Creek Capitol building in Muscogee, Oklahoma, and that building is still standing today. The Creek Nation has a very sophisticated complex of buildings that serve as its headquarters in another part of Muscogee. Indian country includes 3 different definitions, but for purposes of today's presentation, it's worth only noting 2. One is the definition that Indian country includes individual Indian trust and restricted allotments. And the second is that Indian country includes all land within reservation boundaries. That means that lands owned by Indians and non-Indians are included as Indian country if they are within recognized reservation boundaries. Indian country is significant with regard to the establishment of which governmental entity has jurisdiction over crimes committed there. The state retains jurisdiction over non-Indian against non-Indian crimes and victimless crimes. The federal government has exclusive jurisdiction over certain major crimes by Indians against Indians under the Major Crimes Act. The federal government also has jurisdiction over crimes by or against Indians under the General Crimes Act. And tribes have jurisdiction over certain Indian against Indian crimes. And this is significant not only in Oklahoma, but all throughout the United States. There have been a number of decisions involving Indian country in Oklahoma before the McGirt and Murphy cases were decided. One of the first was a recognition by the United States Supreme Court in 1926 that an Osage trust allotment was Indian country and subject to exclusive federal jurisdiction for the prosecution of the murder of an Osage by a non-Indian. More recently, but still 40 years ago, the courts recognized that Indian trust allotments in western Oklahoma constitute Indian country for jurisdictional purposes. Then the courts also recognized that unallotted tribal lands and restricted allotments are also Indian country in eastern Oklahoma. The Cherokee and Creek Nations were already operating courts and police by the time the Cravat decision was issued by the Oklahoma Court of Criminal Appeals in 1992. And the Choctaw and Chickasaw Nations also had judicial branches at that time. These decisions led to federal court prosecutions of Indian against Indians for certain felonies under the Major Crimes Act in Indian country, and also federal prosecutions of other crimes in Indian country. It also led to expanded tribal law police forces, more active tribal courts, and more tribal prosecutions of Indian offenses, usually classified as misdemeanors. After another 25 years passed, Murphy was decided and expanded the area to include all lands within the Creek Reservation boundaries. The Murphy case was decided a few years before McGirt by the 10th Circuit in 2017. And the Murphy case held that the Creek Reservation was never disestablished. It held that an on-reservation murder of a creek by a creek on fee lands was not subject to state criminal prosecution. I think that decision is a very valuable decision because it contains detailed summaries of pre-statehood laws, including a breakdown of the Creek Allotment Act. The 10th Circuit found in Murphy that allotment era statutes did not abrogate the federal government's authority and responsibility, nor allow jurisdiction by the state of Oklahoma. The Supreme Court affirmed Murphy in 2020 by a separate order on the same date that McGirt was decided. The McGirt decision held that Congress never disestablished the Creek Reservation. It held that the state had no jurisdiction to prosecute offenses by a Seminole against another Indian on fee land on the Creek Reservation. The decision was a 5-4 decision, with Justice Gorsuch writing the opinion. Chief Justice Roberts wrote a dissenting opinion, which contains quite a bit of the arguments that the state had presented to the court. This year, the Oklahoma Court of Criminal Appeals has recognized that the reservations of the other 4 of the 5 tribes also continue to exist: Cherokee Nation, Chickasaw Nation, Choctaw Nation, and Seminole Nation. I'm going to talk now about the state perspectives and the McGirt findings in the McGirt case. The state's version of history was that the 5 tribes never had reservations in Indian territory because they owned their lands in fee. The state relied on the myth of tribal termination and argued that federal statutes implicitly disestablished reservations. The state also argued that the Major Crimes Act did not apply and that the 1906 Enabling Act transferred all pending cases to state court. The state also argued that everyone knew Oklahoma had the right to prosecute Indians for crimes committed anywhere within its borders, and Oklahoma engaged in that practice for decades. The court, the majority opinion in McGirt, rejected the state's arguments. It found that the Creek Nation's treaties promised a permanent home west of the Mississippi, forever set apart, and assured a right to self-government on lands that would lie outside legal jurisdiction and geographic boundaries of any state. These treaty promises were made in exchange for Creek cessions of large areas of homelands in the southeastern portion of the United States, and the court noted that they weren't made gratuitously. The court stated that under any definition, this was a reservation. The court was at times pretty critical of the state's position and arguments. And at one point, the court said, to see the perils of substituting stories for statutes, we need look no further than the state stories we are offered in the case before us. The court recognized that reservations can be disestablished only by express statutory provisions, and basically declined to look beyond the statutory provisions as long as there was no ambiguity. And the court found there was no ambiguity with respect to the statutes impacting the Creek Nation. The majority opinion found that Congress dealt serious blows to the Creek government, but never withdrew its recognition of it and left the Creek Nation with significant sovereign functions. The court stressed that there were no express statutory provisions disestablishing the Creek Reservation. The court also rejected the state arguments that Indians in Indian country were treated the same as everyone else after statehood. And the court noted that those arguments had been frequently raised in other criminal cases arising in Oklahoma and rarely accepted. The court also noted that the state's practices did not mean it had legal authority, and stated that the magnitude of a legal wrong is no reason to perpetuate it. The court also noted that the state's position calls into question every federal conviction obtained for crimes committed on trust lands and restricted Indian allotments, since Oklahoma recognized its jurisdictional error more than 30 years ago. And this was an apparent reference to the Indian country cases I mentioned earlier that were, with regard to Eastern Oklahoma, were decided more than 30 years ago. I promise I'm not going to read any big lengthy quotes except for this one quote, because I feel like it really captures the essence of the decision in McGirt. The court stated, in the end, only one message rings true. Even the carefully selected history Oklahoma and the dissent recite is not nearly as tidy as they suggest. It supplies us with little help in discerning the law's meaning and much potential for mischief. If anything, the persistent, if unspoken message here seems to be that we should be taken by the practical advantages of ignoring the written law. How much easier it would be, after all, to let the state proceed as it has always assumed it might. But just imagine what it would mean to indulge that path. A state exercises jurisdiction over Native Americans with such persistence that the practice seems normal. Indian landowners lose their titles by fraud or otherwise in sufficient volume that no one remembers whose land it once was. All this continues for long enough that a reservation that was once beyond doubt becomes questionable and then even far-fetched. None of these moves will be permitted in any other area of statutory interpretation. That would be the rule of the strong, not the rule of law. I'm now going to give you just a a pretty bare bones historical overview of the 5 tribes before statehood. And this does not focus on social history so much as legal history of the tribes. There's simply not enough time in this presentation to get very deeply into details, but I would like to talk about some of the major events affecting the 5 tribes. Again, this history is something that I never learned when I was in school until I went to college and actually enrolled in a course that involved Native American history and began doing reading on my own. And I'm afraid, even my children have said that they were not taught any of this history more recently when they were in high school. The 5 tribes history in the Southeast, just to hit some of the very basic points, is that they had homelands in the Southeast. They resisted trespasses on their lands by non-Indians who flooded into their lands early on in the 1800s. And these non-Indians flooded their lands without any legal rights. The Cherokee Nation filed federal cases to resist the takeover of their lands, and that resulted in one of the landmark cases, Cherokee Nation versus Georgia, that recognized the unique status of Indian tribes. The tribal citizens were first forced out of their homes. The state courts in the Southeast assisted in the ouster of tribal citizens through fraudulent land practices. Tribal citizens became impoverished and basically lost their homes and had little recourse. This situation resulted in the 1820 and 1830s removal treaties with the 5 tribes. And the tribes were careful to make sure that the treaties included provisions that would protect their new homelands in Indian Territory. Some of those provisions included the promise that they would maintain their lands forever, that they would have governmental authority in Indian Territory, and that no state would ever be formed there, and also that they would receive deeds to their new lands. Some of the tribal members voluntarily removed to Indian Territory, but many did not, and over a period of time between 1831 and 1842, the tribes were forced to remove to Indian Territory, and during that time, thousands lost their lives. Unfortunately, most of this history repeated itself when non-Indians again began illegally seizing tribal lands in Indian Territory in the late 1800s. This map shows the large area that was occupied by the 5 tribes, this huge area that includes Florida in the southeast part of the United States, and they exchanged these lands for the much smaller area here in Indian Territory. And they acquired deeds to those lands. The Indian Territory lands were Osage Aboriginal lands that had been ceded to the United States. The tribes only had a fairly short period of time to get reestablished in Indian Territory, to continue to operate their governments and build homes and towns and govern there before the Civil War came along. And many of the tribe's citizens and leaders supported the Confederacy in the Civil War. The United States required them to engage in or to negotiate new treaties after the Civil War, all of which were done are negotiated and approved in 1866. And these treaties protected earlier treaty rights, except to the extent there were any inconsistent provisions in the 1866 treaties. So, and they also included protections of the tribe's governmental rights in their respective reservations. And the post-Civil War treaties did require the tribes to cede a large amount of land in Western Indian Territory, and those ceded lands were set aside for other tribes. This map shows the area that the 5 tribes continued to occupy in the southeastern and south central part of Indian Territory, and other tribes were settled in the western area. That assigned lands remained unassigned to tribes for a while. There were tribes in central Oklahoma. The Osages occupied their reservation in the north portion of Oklahoma. So you can see the 5 tribes basically gave up about half of their lands once again after the Civil War. It wasn't too long after the Civil War that allotment as the national policy began, and the rationale for allotment was that holding tribal lands in common was communistic, and that tribes did not use all of their lands and did not need them. There were some people in good faith actually believed that assimilation would be good for Native Americans, but the motive underlying much of this rationale was that by allotting tribal lands to individual tribal citizens, the tribal lands could be open to non-Indian ownership. So in 1887, Congress enacted the General Allotment Act, also known as the Dawes Act. The 5 tribes were not included in the Dawes Act, and they were very politically astute. They had their connections in Congress, and they held a trump card because they did own their lands in fee and held deeds to their lands. So the United States could not sign allotment deeds on behalf of the tribes. It would require actions by tribal officials. The Dawes Act resulted in the allotment of large amounts of Indian reservation lands and the loss of approximately 90 million acres of Indian land nationwide, and it included tribes in the western and central portions of Indian Territory. It, as planned, also enabled non-Indian settlers to obtain ownership of land in Western Indian Territory. And one way of doing that was to open the land up by the land runs that is such, for some at least, a popular aspect of the history of Oklahoma. For others, it's perhaps a little more questionable. During this time, there were federal courts in Indian Territory, and the criminal prosecutions were split between tribal and federal courts. This began in around 1877 and continued up to the time of statehood, and there were many federal laws that dealt with the federal courts and defined the jurisdiction the courts had in Indian Territory. The 5 tribes valued their own courts as a way of maintaining governmental control, and that was probably in part due to the past bad experiences they had suffered at the hands of state courts in the southeastern United States before removal, which assisted in land frauds with regard to tribal members there. Only 10 years before Oklahoma became a state, the United States Supreme Court recognized in Talton versus May that the Cherokee Nation had exclusive jurisdiction over the murder by a Cherokee of another Cherokee in the Cherokee Nation under its treaties and the 1890 Act. The 1890 Act is also known as the Organic Act, and that is the law that authorized the establishment of Oklahoma Territory and Western Indian Territory and left the 5 tribes in the reduced Indian Territory. The Organic Act authorized non-Indian territorial government only in Oklahoma Territory, and it did not disturb the 5 tribes' governments. In fact, it expressly protected the civil and criminal jurisdiction of the 5 tribes' courts over their citizens. There was never a territorial government created in the reduced Indian Territory, and it remained subject directly to tribal and federal governance. This map shows the reduced Indian Territory in 1891 after Oklahoma Territory was created in the western and north central portions of what is now Oklahoma. In addition to the motives for allotment on a national scale, there were other motivations in Indian Territory. One of these was the great expansion of railroads traveling through Indian Territory, and that increased the value of railroad towns. And by the late 1800s, hundreds of thousands of non-Indians had come into into the lands of the five tribes without authorization, for the most part, although sometimes lands had been leased to them by the tribe. And there was a great desire for the tribal lands by the non-Indian intruders. Also, another compelling motive for allotment in the five tribes' lands were the natural resources. There was a great wealth of timber and oil, which was discovered around 1901, and also coal, which even then was valued at more than $4.3 billion. As the historian Angie DeBow recognized in one of her books, many interior officials held shares or board positions in the very oil companies who sought to deprive Indians of their land. So this obviously makes some of the actions of some of the interior officials at least rather suspect. Congress was still faced with a problem, in its view at least, of how to deal with the five tribes. So in 1893, it established the Dawes Commission, and the purpose of that commission was to negotiate to extinguish the five tribes' land titles, prepare citizenship rolls, inventory tribal lands, and divide the tribal lands into allotments. And the commission operated between 1893 and 1905. The Cherokee Nation challenged the Dawes Commission authority in cases decided against it by the Supreme Court during that period of time. Congress was still concerned that it couldn't deed tribal lands to others without engaging in an act of confiscation due to tribal fee ownership. Other tribes across the nation, most of their reservations were held in trust by the United States. So when the United States wanted to dispose of tribal lands or free them up for non-Indian ownership, the federal officials could simply sign deeds to the tribal citizens and then open the lands up. But they were not so sure that that would be a legal type of action with respect to the five tribes' lands. This led to federal laws such as the 1897 Act and the 1898 Curtis Act. And these laws were very complex, they were confusing, they were often inconsistent, and they involved things such as application of Arkansas laws, expansion of federal court jurisdiction, and threats to tribal courts. And in fact, the court found in McGirt that Congress did eliminate the courts of the Creek Nation. However, the court recognized that the Creek Nation eventually did regain its judicial powers, and it characterized the laws that the state was relying on in its arguments as statutory artifacts from its territorial history. The Dawes Act had a difficult time negotiating with the five tribes, and it took 10 years to achieve allotment agreements. The Dawes Act recognized in various reports that the Indians would not, under any circumstances, agree to cede any portion of their lands to the government. And the Dawes Commission finally gave up on the idea of purchasing tribal lands and used allotment of lands to individual tribal citizens to remove land ownership from the five tribes. In the allotment agreements, the tribes each authorized the principal chiefs, and in the case of the Chickasaw Nation, its governor, to execute deeds to allottees in their allotment agreements. beginning with the Seminole Nation in 1898 and ending with the Cherokee Nation in 1902. And these allotment agreements are very detailed and contain a lot of provisions, but that's outside the scope of the presentation today, and also was not found as relevant, perhaps, in the McGirt case as it was by the 10th Circuit in the Murphy case. The 5 tribes were determined to keep their lands in Indian ownership, and almost all of their reservation lands were allotted to tribal citizens. Their lands were never returned to the public domain or open to any land runs. Only a very small amount were sold by the federal government to third parties. Congress enacted a series of statutes, unfortunately, for the tribes beginning in 1904 that facilitated fraudulent practices, including in state court, and that resulted in huge, rapid losses of the allottees' lands. So Congress basically devised a different way to get at the lands of the tribes and their tribal citizens. The state, as I mentioned, tried to perpetuate the myth that the 5 tribes or the Creek Nations government had been terminated, but the court recognized the Congress had enacted a joint resolution in 1906, followed by a statute, the 5 Tribes Act in 1906, that continued the existence of the 5 tribes in full force and effect for all purposes authorized by law until otherwise provided by law. Basically, the court recognized that the law said what it meant, and there was really no getting around that express type of provision. In 1906, Congress enacted the Oklahoma Enabling Act, and that authorized the merger of Oklahoma Territory and Indian Territory and the creation of a state. And it had placed the laws of Oklahoma Territory in effect as far as applicable. The court in McGirt recognized that the Enabling Act sent state law cases to state court and federal law cases to federal court, and found that that included crimes in Indian country covered by the Major Crimes Act and the General Crimes Act. The Enabling Act also included provisions protecting rights of person or property pertaining to the Indians and preserving federal authority over Indians, their lands, and other rights. I'm just going to talk just for a minute or two about the 5 tribes after statehood. There were many federal policy changes in the 20th century, and those included the abandonment of the allotment policy fairly early on. And then in 1975, Congress began to enact laws that strengthened and promoted tribal self-governance, beginning with the Indian Self-Determination Act and various amendments after that. I think many people think that somehow the tribes just disappeared after statehood, but that is simply not the case. And a good example of that is found in Harjo versus Kleppe, which was a federal district court decision issued in 1976. And the court in that case reviewed the federal laws impacting the Creek Nation closely, but it also reviewed the actions of federal officials and how they treated the Creek Nation after statehood. And the court characterized those actions as bureaucratic imperialism and a determined use of its raw power. The court found that the BIA promoted the erroneous belief that the Creeks possessed only limited governmental authority, and that the federal actions were designed to prevent any tribal resistance to the Department of Interior's administration of Indian Affairs, as manifested in deliberate attempts to frustrate, debilitate, and generally prevent from functioning the tribal governments. And I think it's worth noting that one of the things the BIA did was to keep control of tribal funds. So at times the Creek Nation requested funds to travel to Washington to talk with federal officials about tribal business, and were denied the use of the funds for that purpose. But if it served the federal government's purposes, such as situations where there was a statute that required tribal consent to some disposition of tribal property, then the BIA would recognize the authority of the Creek government. And this history, I think, was repeated to most, if not all, of the other tribes throughout the 20th century. But most of the 5 tribes had written constitutions by the mid-1800s, and they all adopted new constitutions that have since been amended or revised over the years. That includes the 1969 Seminole Constitution, 1976 Cherokee Constitution, 1979 Muscogee Creek Nation Constitution, and the 1983 and Choctaw and Chickasaw constitutions. The tribes have been very active in their governmental, their exercise of governmental powers for decades and decades, particularly since they established their new constitutions. And today they, and have for a long time, exercised judicial authority through tribal courts, law enforcement, and use of criminal codes that they've developed. They also participate in child welfare protection, not only in tribal court, but also in state court. They provide health care services, social services, assist with development of roads projects, provide charitable contributions to local communities, entities such as volunteer fire departments, have engaged in tremendous economic development within their reservations, and employ not only tribal citizens, but non-citizens. The tribes have been a great benefit to the citizens of Oklahoma, in my opinion. And there's no time to really get into the details of this, but if you are interested, take a look at the website of unitedforoklahoma.com, because that sets out much of the detail, including actual dollar figures related to the contributions the tribes have made to the state. I'm going to make a list available of possible reading sources or sources of authority for my talk today, but if you want to look at the Murphy and McGirt decisions, I've provided links here at the end of this presentation, this PowerPoint, and you can use those to actually go to the court sites and look at those opinions. I really appreciate, again, the opportunity to speak with you today, and I think at this point we're going to open this portion of the conference up for any questions that you may have on this topic. Thank you.
All right, we do have a few questions for Susan. We have some questions from, and please keep putting questions in the chat if you'd like. A question from Greg. He asked, Susan, are you aware of the 6th or 7th Circuit Court case decided after McGirt that undermines the holding in Irby in 2010 that the Osage Nation was, quote, historically disestablished?
I've read a little bit about the 7th Circuit decision, which it's my understanding that has to do with the Oneida Nation. And the court there emphasized that allotment alone didn't disestablish a reservation, and it applied 3 different standards with an emphasis on the McGirt holding that the text of the statute controls whether or not a reservation's been disestablished. But I'm not aware of, I haven't read the case, so I'm not aware of the cite to the Irby decision. I do think that McGirt certainly calls into question the Irby decision, which found that the Osage Reservation had been disestablished. And it was a 10th Circuit decision, and it did not apply that strict text standard that was applied in McGirt.
He further asks, are you aware that the City of Tulsa Municipal Court is holding that it has criminal jurisdiction over Indians based on an obscure clause in the Curtis Act that allowed cities established prior to statehood to have courts?
I am aware of that. Actually, I've been doing some research about that. I think the presiding judge of municipal judge for Tulsa, the city of Tulsa, made a ruling that the Curtis Act somehow authorizes municipalities in Oklahoma to exercise jurisdiction within the Creek Reservation, even though the state doesn't, because in McGirt, the court said the state does not have that jurisdiction. So that's seems like a little an inconsistency for sure with McGirt, but I think more important, the Curtis Act has a section that's very long and it deals with authority of municipalities in the Five Tribes reservations during Indian Territory times. It was an 1898 law. And Congress was concerned because hundreds of non-Indians had settled in towns in Indian Territory without authority on tribally owned lands, but Congress was still concerned that they wanted to protect them and the improvements that they had made. So they authorized them to organize towns, and in the Curtis Act in Section 14. But it was a temporary measure, and I think when you look at the history of towns in Oklahoma, that becomes even more clear. But even just looking at the federal law, when Congress authorized the Indian Territory and Oklahoma Territory to be combined into a new state, the 1906 Enabling Act provided that the law that would be applied would be the laws of the territory of Oklahoma. In Indian Territory, Arkansas laws had been applied, and it was those Arkansas laws that were used to form towns in the reduced Indian Territory in the Five Tribes reservations. So the Enabling Act pretty much automatically did away with Arkansas laws when it authorized the state to form. And then when the state did form, the state just practically immediately, the state legislature recognized authority of towns that had been formed under Arkansas law in Indian Territory to continue until otherwise provided by law. And then just very shortly after that, state laws were passed that enabled those towns to incorporate under state law, which I imagine most of them did, but I know for a fact that Tulsa did that. Tulsa incorporated under state law. So to find that Arkansas law somehow authorized Tulsa to exercise jurisdiction that the state doesn't have just doesn't make sense in terms of the laws that apply.
We had a question in a previous session yesterday, actually, that kind of goes along with this a little bit about the possibilities of the McGirt case kind of being applied to other tribes and other nations. Do you see that being a possibility, the decision in this case being applied to other nations?
Well, of course, I've already mentioned it has been applied to the other 4 tribes.
Well, sorry, I meant to say beyond the 5 tribes.
And it has been applied to at least 1 or 2 tribes in Oklahoma already in a positive way, finding that the reservation still continued, but I can't remember off the top of my head which tribes those were. I think there's been maybe one case that's found that an Oklahoma tribes reservation did not continue even with McGirt. I think it's being used around the country though, and I think that Oneida case, that 7th Circuit case, is an example. It's being used to help tribes to obtain recognition that their reservations were never disestablished.
We do have a question. Can McGirt be used to call into question land ownership today?
No, McGirt doesn't have anything to do with the actual ownership of the land. It only has to do with the governmental authority over the land and primarily over Indians on the land.
And this is a question going back to to Indian Territory in the Civil War, was there a territorial or ancestral reason why the tribes supported the Confederacy?
I have not really studied that in depth. I know, I'm sure most people know that many of the citizens of the tribes had slaves, and some of them brought them with them when they came to Indian Territory. So I'm imagining that that was probably an incentive for that support. I think some tribes leaders actually voted to support the Confederacy, while others may not have taken formal action, but they still had people that supported the Confederacy.
And just kind of to go along with that, at our OHS site, the Honey Springs battlefield, you can learn a little bit about some of that history, and also the tribes that fought on both sides of that battle, because there were members of the tribes who fought on both sides of that battle, on the federal side and on the Confederate side. Let's see. We also have a question about the inconsistencies regarding the treatment of Creek freedmen, of Muscogee freedmen. Can you kind of talk a little bit about freedmen and allotment, and can you talk anything about that and how that applies, how the case applies to that?
Well, I can't speak to the treaties much because each tribes had different treaty provisions regarding freedmen. And, there's been litigation about freedmen rights within tribes. I think currently, at least, well, I mean, I don't think just currently, I just think period, the Seminole Nation and the Cherokee Nation recognize that freedmen are citizens, that if they can trace back to the freedmen rolls that the Dawes Commission created, then they can establish their eligibility to be tribal citizens. But as far as allotment goes, I'm not sure, I haven't studied the reason, but for whatever reason, the Dawes Commission set up separate rolls for intermarried whites, for those tribes that actually allowed allotments for intermarried whites, for freedmen, and then for the Indian citizens. And so when you trace your citizenship, you go back to the role of your ancestor, whatever role that ancestor was on. And I think there was some unfairness there in the sense that there were freedmen put on the freedmen rolls that had Indian blood, but the Dawes Commission and the people that worked for them put them on those rolls. So that kind of separated them out. And that was relevant because early on, Congress removed the protections that were given to tribal allotments on freedmen lands. Like in 1904, they were like the first to go as far as being protected. And then Congress moved into the idea of blood quantum, Indian blood quantum, and they took protections away from people with lesser blood quantums. So I think the freedmen got caught up in that in a negative way.
We have time for one more question. We talking about the authority, the governmental authority in this decision. So I've seen in the news that some tribes may attempt to assert taxing authority for resources drawn from their reservation areas. Is there any provision in the law for that action?
I'm sorry, I didn't quite catch the beginning of that.
You said, I've seen in the news that some tribes may attempt to assert taxing authority for resources drawn from their reservation areas. Is there any provision in the law for that action?
Well, that's a difficult question to answer because when you start looking at taxation authority, you're looking usually at case law and maybe treaties too, but as opposed to statutes. So I don't know that there's anything to stop that, but I'm not really aware of what they read in the news about that. So.
Well, we've run out of time. I know that some people may have some other questions, but thank you very much for your time and for this presentation. I know that it's explained a lot of things that people may not have understood about these cases and how they came about and the history behind them. So thank you for joining us today, Susan, and thank you for the audience for listening. We all have another session coming up that addresses sovereignty. So just click on that session next. And thank you all for joining us.
Thank you.